The defense isn't arguing innocence anymore. They've already admitted the misconduct. The only question left is whether this lawyer deserves a second chance, or should lose the right to practice law forever.
The next case on the docket will be the Florida Bar versus Robert Adams. The next case on the docket will be the Florida Bar versus Robert Adams. Whenever you're ready.
Mr. Chief Justice, and may it please the court, I'm William Jung, and I'm here with respondent Mr. Robert Adams. We're here on a very narrow grounds. The sole issue presented by our appeal is the finding of permanent disbarment. We do not contest the findings of fact. We do not contest disbarment, and we don't contest any of the findings, what I might call the convictions on the recommended findings of discipline. The issue presented here is simply whether permanent as opposed to non-permanent disbarment is appropriate. As Mr. Adams did below, he comes here and confesses his serious, egregious, ethical shortcomings.
Well, wait a second. What do you say he did it below? I thought it went through a full hearing by the referee.
Yes, it did.
And I didn't think he only testified at the very end. So when did he confess how egregiously wrong the conduct was?
Your Honor, I believe his direct testimony from the stand was that he has never committed such error in judgment in his 47 years on this planet Earth.
Well, I would hope not. I have never, and I don't profess to know everything about the law, but I have never encountered, and I've been in some rough situations, I have never encountered behavior like this, and calculated and planned behavior. This is not okay, I made a mistake. I shouldn't have signed that check. This was a planned, even planned at one time, and it didn't reach fulfillment, and then did it again, or did it, and then even took the files, this law firm. Took the opposing lawyer's files in the briefcase, didn't they?
Well, Mr. Adams wasn't specifically involved in that, but I'm not here, and he instructed me to come not to defend him or to venerate him.
Well, yeah, but you're saying this is just some kind of simple circumstance. This is not simple.
What I'm suggesting and why we are here is because this court's jurisprudence on disbarment versus permanent disbarment suggests that simple disbarment, which is far from any guarantee of readmission, and in fact, as the court knows, the presumption is against readmission should there be an application sometime after 2021. The presumption would be against readmission, but the referee's recommendation of permanent disbarment is inconsistent. I'm here to venerate the court's guidance and the court's precedents, which do not support permanent disbarment.
Well, it could be we've never seen a case this bad.
Well, Your Honor,
is that possible?
Your Honor, I would suggest the cases that we've cited are not as severe as the conduct that occurred with Mr. Adams, as opposed to his main partner, Mr. Diaco, on the case. First of all, the first time they called the police on opposing counsel, Mr. Adams was out of town, knew nothing about it till after. I don't believe Personius was involved in any way. She encountered opposing counsel perchance in a bar, and then she called Mr. Adams. Mr. Adams spoke to Diaco, who said, call Filth out. Filth out was friends, co-respondent and friends with the police officer.
So he knew, again, there's no question, he was intimately involved with the setup to try to get this lawyer.
This is the moment the hearing takes a dramatic turn. The justices make it clear they don't see this as a simple lapse in judgment. They see a carefully planned scheme that struck at the heart of the legal system.
Arrested.
He was involved.
And he knew the lawyer was a lawyer in a hotly contested case, right?
Yes. Disbarment not permanent to the referee. And that's why the bar, after discovery, said rehabilitative suspension to the referee because of Adams.
When you say rehabilitative, what are you talking about?
The bar agreed to a 91-day suspension for Mr. Adams.
At what point?
At conclusion of all discovery.
But not before it went to trial.
Then the referee said no. There was massive publicity caused primarily by Mr. Diaco's inflammatory statements. The referee said no. We went to trial. He convicted Mr. Adams on everything, and the bar then said what I'm saying right now, disbarment not permanent for Mr. Adams, because he was not involved, had no connection to the police officer, didn't know him.
But the problem I see with your argument is that Mr. Adams is the one that the paralegal called on the important night, correct?
She did, yes.
And he knew what had gone on 2 months before, correct?
Correct.
Even though he didn't know beforehand, but he knew after the
Yes,
fact
ma'am.
what had gone on 2 months before, and then he made the conscious decision to call them and tell them that he's there now.
To call
And
Diaco.
what did
And
he
that-
expect to happen from
and-
giving that information?
Your Honor, what I would expect him to happen is he would be disbarred. He would be disbarred like many other lawyers. F. Lee Bailey, who stole from clients and forged judges' signatures, disbarred without permanency. Like this other series of cases where we've seen where someone who makes a horrible mistake is not permanently disbarred. And I've cited the cases. So he should be disbarred, but he should not be disbarred. The permanency cases, and the the referee never discussed these. He's not like Norkin, who showed up here and smirked and stared down Supreme Court justices at a public reprimand and was permanently disbarred. He should be entitled to have a chance to be rehabilitated in 5 or 6 years with a presumption against readmission. Thank you.
It seems to me every lawyer takes an oath, correct, in this state.
Yes.
And every lawyer is at least charged with knowing the ethical rules, correct?
Yes.
And each lawyer has an obligation to protect his or her own license,
Yes.
correct? And so whether Mr. Philpott was told by Mr. Adams or Mr. Diaco to do something unethical, he had to make the decision about whether or not he was going to participate in something unethical, didn't he?
Yes.
And so it seems to me the fact that it may not have been his idea, the fact that they knew he had this relationship with the police officer does not negate the fact that he chose to participate in a totally unethical scheme.
And that's why I began with the fifth issue and not the first. The fifth issue is whether or not permanent disbarment is warranted. I would suggest to your honors, it is not when you look at the actions of each individual that evening, and more importantly, into the next day.
Wasn't he also a part of all the texting and things that went on that night? I mean, I thought there was like 17 or 18, maybe even 19 different texts between the paralegal and your client.
Judge, I would submit to the court that in candor, there were more. But I think it's important to point out when you talk about the text messaging and the phone conversations between Mr. Philtout and his best friend at the time, Sergeant Fernandez has previously testified under oath that a large majority of that conversations related to totally innocuous conversations about paintball, their children, there's a godfather relationship.
Because what happened to your client's cell phone?
I'll tell you exactly. I'll echo Mr. Jung. What happened is Mr. Diaco hired a third-party lawyer, Lee Gunn. Lee Gunn took possession of all of those cell phones, and that's the extent of the respondent's knowledge of his cell phone. He was ordered to give his cell phone to Stephen Diaco, who then provided all of the cell phones, including the respondents, Ms. Personius, Mr. Adams, to Lee Gunn. And that was done, and I believe, at the direct consequence of Judge Arnold's litigation or this Clem Schnitt litigation due to the spoliation letter that Shoemaker Loop served on Adams and Diaco. And that's important to note that Mr. Philtout is often described in the media accounts and even in this trial as a partner. He's not. He is, for lack of a better term, an associate attorney. He is a non-equity partner.
I'm not sure for this situation that matters. And I know we'll look at your other issues, but was he at all involved in the briefcase?
Zero.
Okay. Not involved in any of the public statements?
Zero.
Okay. And was the bar has brought up additional aggravation with a PIP lawsuit in Miami. Anything on that?
Zero involvement.
No other prior disciplinary proceedings?
In 16 years, he has zero other, and it's important to note that he was a public defender, which when you serve in the criminal justice aspect of being a lawyer, especially in the public defender, you're often dealt with unhappy clients. My client has never, ever faced any disciplinary proceeding as a result of any of his years, 16 years as being a lawyer, which I think is very important.
Mr.
With regard to the phone, the trial judge determined that at trial, both respondent, Dyko, and respondent, Filthout, refused to answer any questions about the destruction of their cell phone messages and are subject to the adverse inference that they too have deliberately destroyed them. Is that, the trial judge find that?
Absolutely, sir. And just to follow up on that, there is evidence that Mr. Adams, through his own testimony at the trial, said that he deleted text messages. There is evidence through Melissa Personius' own testimony at a separate proceeding that she deleted text messages. There is evidence that Mr. Diaco took those phones and gave them to Attorney Lee Gunn. There is zero evidence, zero, that Mr. Filtout deleted a text message, destroyed his phone, did anything other than what he was ordered to do by a supervisor, presumably pursuant to a spoliations letter that was sent by opposing counsel in the Clem-Schmidt case.
That's not what the trial judge found, though.
I don't believe there's any evidence to support, Your Honor, that Mr.
That finding
Filtout...
by the trial judge.
I'm sorry?
The finding of the trial judge.
Yes.
All right.
And I say that respectfully.
You're
Is that
into
an
your...
issue here?
I'm sorry?
Is that an issue here? Is that one of the issues that you've raised, that there was no...
It is.
Substantial competent evidence to support that finding?
It is. If you look to issue number 4, that the referee's findings are not supported by competent and substantial evidence, there is no evidence that Mr. Filtout deleted any text messages or destroyed a phone. There simply isn't. There is a negative inference that the judge makes and uses that as the evidence, and I proffered case law from the United States Supreme Court that states the negative inference alone is not enough, that there needs to be something else.
What makes this case so extraordinary isn't just the alleged misconduct. It's the level of planning behind it. Every phone call, every text message, and every decision is now being examined to determine whether this was a legal mistake or a deliberate conspiracy.
With respect to the other participants, I'd submit that there is. With respect to him, there isn't.
Well,
so I believe that
but
that's
basically, the 19 texts or more texts, you fully admit that the incident, but for Mr. Filtout and his knowledge and friendship with Fernandez, the ensnaring, the entrapping, the unethical conduct of that night would not have occurred. So whatever the text, I mean, I don't know how much worse the text could have been, but unless there's some other conduct, I'm not sure what the additional negative inference is from the text messages. So I guess I'm sort of as a semi-friendly question. What did the judge draw as a result of finding that he had destroyed his cell phone?
Well, the judge ruled two different things. Number one, that he conspired with other people, and then he ruled that Mr. Filtout covered up that conspiracy. And I just suggest to the court that there is zero evidence that he covered up any conspiracy. He didn't, because there's no evidence that he deleted text messages. There's no evidence that he destroyed a phone. In fact, to the contrary, there's evidence through Rob Adams' testimony at trial that Stephen Diaco took those phones and gave them to Lee Gunn. So I think that that's fairly clear, and I submit to the court that the referee simply got that wrong, and I say that respectfully. As to issue 1, I do believe that the respondent was denied due process when the referee denied his motion to disqualify the referee. I do believe, as to issue 2, that the referee erred in denying summary judgment. As to issue number 3, I do believe the referee improperly relied on facts not in evidence. And as to issue number 4, again, we believe the referee's findings are not supported by competent and substantial evidence.
But you do agree that if you get through that just, you're not contesting disbarment, or you are? Are you arguing for a lesser penalty than disbarment?
I'm arguing that this individual have an opportunity at some point in the future to reapply for his license to practice law.
Okay, so you're agreeing to, even with all of these, unless we found the judge should have recused himself, that he should be disbarred.
I started off with number 5.
Okay.
And I did so for a reason.
Thank you.
Mr. Filtout was the ingredient in this conspiracy that made it work. Without Mr. Filtout's personal close friendship with a law enforcement officer who trusted him and didn't have a suspicion of what was going on, this would not have happened.
Let me ask you, but here's my question, and it's, we've got one defendant, respondent, that's agreed to permanent disbarment. Another, and was involved in the briefcase incident, which is outrageous from my way of thinking, and also made public statements which revealed the motivation in this and was involved in that lawsuit and was a partner. We have criminal cases, and you look and say at the end when they're sentencing, we got 3 defendants. Sometimes we talk in proportionality about equal culpability. I think in the eyes of the law, clearly he's equally culpable for what happened that night and the setting up. But the question is, in terms of the ultimate sanction, that everybody gets the ultimate sanction so that this will never happen again. The word is, it will never happen. But isn't there some distinction between what Mr. Diaco did as the partner involved in the litigation and Mr. Filthout, and if not, just, and again, I'm trying to understand that, and right now, appreciate the candor that everyone is agreeing their disbarment is appropriate. So could you explain why, you gave us some reasons for Mr. Adams, why for Mr. Filthout?
Yes, Justice Pariente. Mr. Filthout never testified in this case. He had the opportunity to. He had the opportunity to even hear Mr. Adams' testimony, think about it overnight, and yet he still stood firm and refused to testify, to stick together with the co-defendants. Mr. Filthout should not be...
Are we allowed to draw, because this was an ongoing, and I think we do, that the exercise of his Fifth Amendment right, we can, based on that exercise, draw an adverse inference, that he's entitled to no mitigation. But what's the not testifying? Does that mean he's showing no remorse? What is the significance of that here?
Yes, the significance to the bar is that if Mr. Filthout is allowed to have a lower sanction, he's being rewarded for failing to be forthcoming, to failing to have candor, to invoking his Fifth Amendment. He should not be rewarded for that behavior. There was a lot of aggravation, not just his personal relationship, dishonesty during the disciplinary proceeding.
I guess the bottom line of this whole thing, where you have this groupthink, where this happened. What happened to the old maxim, a lawyer sees this happening and says, guys, I can't do this. This is wrong. I'm out of here. Quit your job, whatever. I'm out of here. I'm not doing this. Whatever happened to that? I'm just wondering.
Justice LaBarge, I take it that that's not just a rhetorical question, but yes, that is exactly the point. All of these attorneys conspired together and committed these acts willingly, knowingly, intentionally for a bad purpose.
Hearing is, well, this guy did this guy didn't do that, this guy talked, this other guy didn't. They're all in this together. And the whole purpose of the whole thing was to damage this other person's reputation, one way or the other, and in there somewhere there was some advantage that they thought they would gain from this. But again, people are talking about doing something wrong, something bad. You're a lawyer. You took an oath. I can't do this. And if it means, hey, I'm not going to be getting a paycheck from this firm tomorrow, fine. Go back to the public defender's office, go to the state attorney's office, whatever. But we don't do this. That's the whole thing here. When I'm talking about who's more culpable, they're all culpable.
I agree with you, Justice LaBarge. It's been said that character is who you really are when nobody is watching. And in this case, the respondents, both Mr. Adams and Mr. Filthout, their conduct shows that they have bad character and they should not be allowed ever to practice law again. It's also said that character is who a person really is, but reputation is just who other people think the person is. And even though the respondents had put in as mitigation that they had character evidence in their reputation and the good deeds they had done, that is not enough to overcome the severity and the horrible nature of this, and anything less than permanent disbarment I would argue to this court, will not be a sufficient deterrent to other attorneys to dissuade them from engaging in similar behavior.
Picking up on that last point, at one point the Florida Bar felt that 91 days was enough to deter other attorneys from this type of behavior. After the trial was over and the respondent was found guilty, the Florida Bar felt that non-permanent disbarment was enough to deter attorneys from this type of behavior. Now, all of a sudden, it is permanent disbarment. I would suggest to the court, and Mr. Chief Justice, I will answer your question because I believe it's very important to you, and that is, an individual can be as guilty as someone else, but that doesn't mean that their punishment must be the same as someone else. There are different roles in the actions of multiple individuals. And because there are different roles, there are often meted out different punishments. Some are higher than others, some are lower than others. When you look at, and I say this not to besmirch anyone, but you have Stephen Diaco over here with the trial bag and the statements to the media and anything that he did that night, he was involved with everyone. He had contact with all the parties. Then you had Robert Adams, who falls below Mr. Diaco. And then at the far end of it, you probably have Mr. Matroni, who was determined by the Florida Bar to be acting at the direction of his supervisors. I'm not telling you that Mr. Filtout is right next to Mr. Matroni. I'm simply arguing that he's not close to Mr. Adams and Mr. Diaco. He's somewhere in the middle. And as a result, I think his punishment should be less than those two individuals, but greater than Mr. Matroni. It's important to note that his only involvement in this is but for the fact that he knew Sergeant Fernandez. Don't you think that was known by the individuals in this case? Don't you think that there's a certain amount of manipulation that was done by Mr. Diaco with everyone involved? And
that's all well and good, but your client is a member of the Florida Bar and had been for over a decade at the time this took place. And he had, as the Chief Justice just said, he could have walked away from this, but he stayed in the mix twice, and I just don't see how he's not as culpable as the others.
Madam Justice, I don't dispute that, which is why I'm not asking for a letter that goes in his file or a suspension of 10 days or even a suspension of 91 days. What I'm asking for is a punishment that essentially meets his involvement in the crime. I'm not talking about culpability.
But the reality is there's not an unlimited range of punishment. I mean, the worst we can give is the permanent disbarment. So the fact that someone did something worse and only can get permanent disbarment, that's just a kind of part of the structure of reality that we're faced with. Now, perhaps if something more could have been done, it would be done, and because there is an extra element of culpability. But we have.
After reviewing every argument, the Florida Supreme Court reached a historic conclusion. The justices ruled that the misconduct was so shocking and so deliberate that permanent disbarment was the only appropriate outcome. It was a decision designed not only to punish those involved, but to warn every attorney that manipulating the justice system comes with permanent consequences.
And I would suggest to the court it's not, because what you have is, like as you said, a limited amount of options before the court. And if you're going to assign the worst punishment to the worst actor, that's appropriate. At that point, then you go below. It's like that in the criminal justice.
See, I just don't buy the logic of that, because sometimes people that have been involved in may not be the most culpable are still eligible for the highest sanction that we have available. I don't follow the logic of what you're saying.
And I understand that. I'm simply arguing to the court.
I understand it's an argument.
It is our position that he is deserving of a less punishment than Stephen Diaco, and to the extent perhaps even Mr. Robert Adams. I would also suggest to the court, just going back to the...
You're well over.
Oh, well, then I'll suggest to the court I will sit down.
5 minutes there.
Thank you.
Thank you. Okay, the court's in recess. Thank you for your arguments.